Hello and welcome. My name is Avi Charney, the founder of Charney Legal. Here we deal with estates and real estate matters. You know, in my previous video I noted how so many people don't have a will. And now I'm going to be talking to you about multiple wills. What's the deal with multiple wills? Why have even more than one will? Now, it's important you have one will. Let's start there. But I'll explain why people elect to have multiple wills. As a first step, your main will puts in all your assets. You can start there. When you have that will, you have to submit it to probate, to the court, to get approved. I have one of my very first podcast episodes was with Donald Carr. He is a legend estates lawyer. He's been doing this for longer than I've been alive. I think he was called to the bar in 1951. He was involved in the very first case which introduced multiple wills to Ontario, called the Gronofsky case, Gronofsky Estate versus Ontario. I'll link it below. He explained to me in the podcast, worth listening to him explain the whole process, but my interpretation of the process is the primary will gets submitted for probate and certain assets can go into the secondary will, and by having that secondary will, they avoid probate. They don't have to be submitted to the court to get probated. Now, why does that matter? Main reason is taxes. Primary will gets taxed, and in Ontario, that tax rate is 1.5%. It's not the huge deal. There's other taxes which you also have to be cognizant of, but 1.5% is still something which, if you could avoid it, you might as well avoid it. So the secondary will, what is the deal with a second will? Corporate assets, shares in a private corporation that you control, that you own, can go into the secondary will. Also, personal items, personal effects can go into the secondary will. Those are the main items. Some other main assets, assets held on a resulting trust, certain registry real estate, and debts owing to the deceased. Those are the main ones going to the secondary will. And by going into the secondary will is not submitted to probate, so there is no tax on the secondary will, and that's really the key, not being taxed. Now, some people get fancy and have a third will or a fourth will. A couple of reasons I can think of for having more than two wills even, is if you have foreign property. Think if you have property in Europe or the States or whatever it is, you don't have to go and submit your Ontario will to these foreign jurisdictions. First of all, because like I said, the first will is subject to probate tax. You don't want to have to be doubly taxed by submitting that will in another jurisdiction. You may get taxed over there as well. Also, there may be specific laws that apply in that jurisdiction that me as an Ontario lawyer don't necessarily know. So what I suggest when clients have property in another jurisdiction is go to a lawyer in that jurisdiction and make a little simple will to cover that property in that jurisdiction. So based on our little chart over here, we now have three wills. The primary will, the secondary will with the corporate assets and personal assets, and the third will which could contain foreign assets. A fourth will, one other example I can think of, if someone wants to keep something private, again, they don't want to submit it to probate, and so that will can govern certain assets that are private. Now, as you can see, there's a need for obviously one will, but sometimes multiple wills depending on your circumstance. Some people say wills are expensive, but I guarantee however much you're going to pay for a will, it'll save in the long run the aggravation and the conflict that may arise without having proper planning in place, and the taxes ultimately. So like anything in life, it's worth it to invest up front and do it right to avoid the taxes and the headache down the road. Now, just a couple of notes that when drafting these wills, you have to be careful. A typical will has what's called a revocation clause, which starts at the very beginning, I revoke all previous wills. Now, if you're going to do that on your second and third will, revoke all previous wills, you're going to revoke your first will and then you're in trouble. You have to be very careful that they're drafted, all your wills, whether it's 1, 2, 3 or more, are drafted in a way that complement each other and in a way where they're synthesized together so that one doesn't revoke the other, and that they work together to benefit your estate and your beneficiaries. If you need legal advice, drafting 1 will, 2 wills, whatever the case may be, you can feel free to reach out. Remember, it's always important to plan in advance to avoid headaches down the road. Hope this has been helpful. Bye for now.